she moved at trial to exclude testimony about DNA evidence. They said, I got the DNA of the president. Oh, great. Good. Prove that. Let us see it so that you can prove your claim, right? And she declined to offer to test the DNA evidence. If you have the evidence, maybe you should use it. She didn't. Clearly suggesting that she expected the DNA evidence to contradict her story. She claimed that in 2005, Trump suddenly grabbed her shoulders and kissed her without her consent at Mar-a-Lago within a short distance, right in front of everybody, during a break in her interview with both Donald and Melania Trump. What? President Trump going to the Supreme Court in the case of E. Jean Carroll. We've been waiting for this one. This was the lady who said that Trump Bergdorfed her in a dressing room in Bergdorf's, that old department store, a long time ago. She couldn't really remember when or what happened, or there's no corroborating evidence at all. And the witnesses that she allegedly called after the event all were like, this lady's whack. She's also had a weird fixation with Law and Order. You remember her. She's on the thumbnail, and the AP is reporting that now she is getting appealed. And this is the photograph of her over at the Caring Foundation. She's like a superstar there on the left. And the lawsuit, as we know, and as they're going to mention in the Supreme Court petition, was funded by the left. Guys like Reid Hoffman were dumping hundreds of thousands of dollars into her operation. They basically revised the law in New York to allow her to file a lawsuit. Trump responded to a lot of this while he was the president, saying this lady's whack. And then she sued him for defamation. On petition for writ of certiorari to the Supreme Court, coming out from President Trump and the DOJ. Second Circuit, they came down and they said, Trump, you lose. They denied Trump's request. And so now we're knocking on your door, SCOTUS. Here's the background. In case you forgot. They write, all right, Supreme Court, remember this. In 2019, E. Jean Carroll, she first raised facially implausible, politically motivated allegations against President Trump about conduct that purportedly occurred decades earlier. President Trump has clearly and consistently denied that this supposed incident ever occurred. No physical or DNA evidence corroborates her story. There were no eyewitnesses, no video evidence, no police report or investigation at all. Carroll admittedly never reported the supposed incident to the police or sought video footage from the department store, Bergdorf's, where it allegedly happened, despite claiming that footage did exist. Weird. No reference to the supposed incident exists in decades of subsequent communications with her supposedly bolstering witnesses that we'll talk about. Instead, Carroll waited more than 20 years to falsely accuse Donald Trump, who she politically opposes, by the way, until after he became the 45th president, when she could maximize political injury to him and profit for herself. And notably, her allegations are a story that precisely matches the plotline from an episode of one of her admittedly favorite TV shows, Law and Order. Dun dun. To have any chance of persuading a jury, as Judge Menashe explained in his dissent at the Court of Appeals, Carroll's implausible, unsubstantiated assertions had to be, and repeatedly were, propped up by a series of indefensible evidentiary rulings, improperly admitting highly inflammatory propensity evidence, which is evidence that tends to show that you're going to do it again. These striking departures from the federal rules of evidence erroneously allowed testimony about multiple decades old, unverified, and unrelated allegations to be presented to the jury that had no bearing on the facts of this case. As a result, quote, the judge said, no one can have any confidence that the jury would have returned the same verdict if the normal rules of evidence had been applied. Yeah, we know why they weren't. Now, under the laws, the same rules should apply equally to all defendants. The Second Circuit's decision, which is now embracing a series of anomalous holdings to affirm the judgment of the lower court, created and deepened multiple significant circuit conflicts over the interpretation of important rules of evidence. First, the Second Circuit's decision to truncate Rule 403 when admitting propensity evidence conflicts with decisions by the First, Seventh, and 10th Circuit, which have correctly held that district courts should apply the same Rule 403 analysis that they would apply to any other evidence. Okay, so how do you treat evidence under this Rule 403? Second, the Second Circuit's erroneous conduct-specific approach conflicts with the plain text of other rules, and it ignores a categorical approach. And in other words, the Second Circuit is just garbage. All right, Supreme Court say you need to do something about this. They write. In 2012, the TV show Law and Order, SVU, dun dun, ran an episode in which a business mogul fantasizes about R-ing a victim in a Bergdorf Goodman dressing room while she was trying on lingerie. It's Law and Order SVU Season 13, Episode 11, with that one actor, that everybody loves. Aired on January 11, 2012. Now, this plot line is virtually identical to the false allegations that E. Jean launched against President Trump more than 2 decades after the supposed incident, with not even Carol being able to provide an exact date. It kept changing. We don't know. Was it like 25 years ago, 24 years ago? She's like, well, ballpark. You're like, Judge, we need a little specificity in this case. It's close. It rings true. It has all the hallmarks of an attack in Bergdorf's. Carol admitted, she said, I'm a big fan of Law and Order, but she conveniently professed not to watch SVU. Yeah, right. We know you did. Everybody did. It's the most popular one. But even she called the identity between her allegations and a plot line an amazing coincidence. E. Jean, isn't it strange that you're saying something happened and it's literally exactly what happened in Law and Order? Well, that's astonishing, she says. Wow. Carol also acknowledged that other parts of her story are inconceivable. She agreed that it was inconceivable and cannot be imagined that there was supposedly not a single other person on the 6th floor of Bergdorf's, a busy New York department store at the time that she allegedly got Bergdorf. She also admitted that it was an amazing happenstance. I know everything's so amazing, weird, that the dressing room door was supposedly unlocked and open instead of closed and locked per their policies. Bergdorf's is a big, nice store, or was, I suppose. And Trump, according to her, just waltzed on in there. And he didn't even take a number of items that he was supposed, apparently. The lack of objective and physical or corroborating evidence also undermines her story. Even though Carol falsely and publicly boasted that she possessed Trump's DNA, remember that crap? She moved at trial to exclude testimony about DNA evidence. They said, I've got the DNA of the president. Oh, great. Good. Prove that. Let us see it so that you can prove your claim, right? And she declined to offer to test the DNA evidence. If you have the evidence, maybe you should use it. She didn't. Clearly suggesting that she expected the DNA evidence to contradict her story and support President Trump's position. Now, Carol claimed that she believed that Bergdorf Goodman could have video evidence of the alleged incident, but she never took any steps to obtain or preserve that supposed evidence, of course. Now, Carol never filed a police report, never sought an investigation, never made any public accusation against Trump until more than 20 years after the incident when he became president. Now, tellingly, through years of discovery and media interviews, strangely, Carol could not even recall the exact actual date and time of the incident, further preventing Trump from defending it, from testing her story through objective evidence to say, I can look at my schedule and I was not even in New York at the time. Can you give me a date so I can validate it? No, it happened in this 2-year window and it's probably going to happen whenever Trump was in town, whatever, right? Then once discovery was closed, she took the stand at trial and suddenly and inconceivably recalled for the first time and with dazzling specificity, the incident, we remember, occurred on a Thursday evening in the spring of 1996. She's like, perfect. A date and time that conveniently matched information that Carol had obtained in discovery. So in other words, she requests some information from Trump, like maybe they get his itinerary and they're like, oh yeah, he's in town. And she's like, oh, perfect. He admitted he was in town on this date. She comes out at trial. We were all shocked. We were covering this trial at length, both of them. And the second time, like, what? She suddenly remembered the date? This is ridiculous. For years before that, no date. Carol openly admits she's also a professional fabulist, aka we'll call her a liar. She stated under oath that her public writings are not truthful, but they reflect a fictional public persona called Ask E. Jean, her alternative personality, who is a figment of her imagination and does not reflect Carol's own thoughts and attitudes, like a crazy person. Now, Carol never explained why the allegations in her published book about President Trump came from the supposedly truthful private E. Jean Carroll, as opposed to the fictional untruthful persona Ask E. Jean, who supposedly authored all her other public writings. Interesting. So she changed her identity. In fact, Carol's original versions of her book did not mention President Trump at all. No. Trump was only added well after the project began, and even then, he was not permanently fixed in the book until the very end. They had to shove him in there, 1, to sell books, and 2, so that they could attack him to sue him. Now, Carol's story also suffers from a tidal wave of bias evidence. E. Jean admitted that she detests President Trump. She said it, stating that she watched in horror as he won in 2016. She described Trump as evil and vile. Her idea to sue Trump was crystallized during a conversation with the other maniac, the Oompa Loompa, called George Conway, the obsessed anti-Trump activist. During her deposition under oath, Carol falsely denied that she received litigation funding from an outside source. We know she did. But later, she admitted that the anti-Trump maniac and the guy who went to Jeffrey Epstein's island several times, we believe, billionaire Reid Hoffman, was financing her case. And he hates Trump too. Now, the district court in error declined to continue the trial, order an adverse inference due to the late revelation. She's like, oh yeah, I am actually getting funded by all these Democrats. Hoffman has stated that he would spend as as much as he possibly can to avoid another Trump presidency. And how'd that work out there for you, Reed? Hoffman's plan failed. Just be an honest person and just, have good policies and you can win elections. You don't have to fund psycho ladies to create lawsuits against your political opponents. Maybe just be a good person for once. There is more. Carol admitted that she coordinated with her two outcry witnesses, Carol Martin and Lisa Birnbach. We both listened to them testify before publicizing her false allegations. She shared a draft of the book. She said, hey, I'm going to publish this book. Do you think you guys can back up my fake story? Even worse, Carol communications with Martin reflect a deliberate plot to slander Trump. In an email to Carol on November 11th, Martin described Trump's recent election victory as an apocalypse. They're all crying about it. Expressed, we have to do something to stop the train. No, there are no brakes on the train. We're not stopping. Just be good people with good policies. You don't have to create lawfare and sue everybody. Then on September 23rd, 2017, in an email that Carol did not produce in discovery, and why should she? There's not going to be any consequences from it from the federal judges. Martin wrote to Carol, one of the witnesses, warning of President Trump's tenure. This has to stop. As soon as we're both well enough to scheme, we must do our patriotic duty again. I guess what is that? To scheme? That's all they're good at. Just be a good person. Carol replied, totally. Let's scheme and have something special for you when we meet. Martin, the witness, so-called, who was helping scheme, later testified that the something special that they would advance and their patriotic duty to in this scheme to stop Trump, what did she say when she testified? Oh, it was a stuffed squirrel. Oh. Well, we're just gonna make a stuffed squirrel and yell at it or something. That's their scheme? No, we know what the scheme was. This stretches credulity between the breaking point. This whole case did. Now, to try to buttress her implausible story, Carol also relied heavily on propensity evidence. Okay, if Trump said something or did something, then it's likely that he did this thing. Do you have any evidence he did this thing? No, but he said all these other things, which make us believe that he had the intent or the capacity to do this thing. Specifically, the equally implausible and biased testimony of these two people, Jessica Leeds and Natasha Stoynoff, as well as the Access Hollywood grab them by the purse tape. In her opening statement and closing argument, Carol's lawyer repeatedly emphasized this improper propensity evidence. He says, you heard Jessica Leeds, you heard Natasha Stoynoff, I think it was Roberta Kaplan, tell you how he used this exact same playbook with them. They say, what? Okay, well, Jessica Leeds, let's break this down. They say Leeds, she raised facially implausible allegations against Trump in October 2016. October surprise, more assault claims, 37 years after her alleged date, which was not identified for years, of another incident involving Trump as part of a media pile-on after they released the Access Hollywood tape. They all flipped out about it. Leeds falsely testified that in 1979, Trump, then a successful real estate developer, supposedly assaulted her suddenly and without warning, out of the blue. He just lunged at me while sitting next to her in the first-class cabin of unspecified origin. This one's not a dressing room at Bergdorf's. It's on an airplane. Says, in Leeds telling, this very aggressive physical struggle occurred in full view of the first-class cabin filled with other passengers. At first, she claimed 15 minutes, actually a few seconds when she realizes how dumb that sounds. Leeds also testified that in full view of other passengers in the flight crew, Donald Trump supposedly tussled with her, trying to kiss me, trying to pull me towards him, grabbing my breasts like he had 40 zillion hands in the tussling match between the two of us. This alleged tussling match ended after Leeds supposedly stood up, stormed away, at which point Trump, in full view of other passengers, was also supposedly standing up, lunging at her from the window seat into the aisle, and no one said a word, including her. This whole thing happening in the first class department. Everybody's, wow, this is really interesting. They must be in a little argument. Now, she admitted, they said, well, this is strange. How come nobody else reported this? You didn't file a report. Can you even tell us what day it was? Was he even on that flight? Can we prove that? Can you validate that? Where were you coming from? Where were you going? Let us cross-reference it. None of it. Just on some plane sometime somewhere. Now, then she admitted she is politically active. Oh, guess what? She's a Democrat. Yeah. Who donated to Democratic Senate candidates and obtained a Hillary Clinton campaign button for her daughter. Yeah. She conceded that she hoped her story would literally influence the election against Trump. Much like Carol, she could not recall the origin date or flight, making it impossible to verify or falsify her story at all. Just check the records. See if did you sit next to him or are you just a liar? Now, here's another one, Natasha Stoynoff. Her allegations suffer from similar credibility problems. She claimed that in 2005, Trump suddenly grabbed her shoulders and kissed her without her consent at Mar-a-Lago within a short distance, right in front of everybody, during a break in her interview with both Donald and Melania Trump. What? All right, saying, yet directly contradicting her later claim of being assaulted at Mar-a-Lago, shortly after the incident, she wrote a glowing profile of Donald Trump and his marriage in People magazine without any suggestion of anything problematic at all. It's like, oh, I forgot I wrote that piece where I said it was an amazing time and I enjoyed everything. Well, Well, what I meant was he attacked me in front of Melania. What? Stoyanov wrote that Donald Trump enjoyed marital bliss, that his wife was glowing, and that he reveled in being a twosome, and that he is romantic but very private, and that Melania expected that he would be a fantastic dad. She made no accusation against President Trump until 11 years later, right in October 2016, weird, when she suddenly joined the media feeding frenzy after everybody was Access Hollywooding themselves to death. And this was in the aftermath of Weinstein and the rest of, really disgusting people. They're like, oh, perfect. We'll just make Trump like them. Like Carolyn Leeds, Stoyanov is politically hostile to President Trump, testifying that she viewed him as terribly unfit and that she was happy after the 2020 election. Interesting. So her fake story was great, elevated her status, and completely incongruent with her prior publications when she was writing as a journalist. Didn't mention that. Wouldn't that be a pretty big story? And did they have cameras rolling saying Trump attacked her in the middle? There was a break in her interview. And so they're all sitting there on the couch and he just lunges over there and tries to make out with her. They didn't have that on camera? Apparently not. That would have been a big story, but it wasn't because it didn't happen. Here in 2019, Trump, through official White House channels, when he was the president, okay, we have presidential immunity that they didn't consider, denied false allegations against him. It got published in New York. They were attacking him after winning because they needed to pull out all the stops so 2020 wouldn't lose again. He made these statements from the White House in response to press inquiries as a matter of public interest. And the White House press office distributed his statements, and he's allowed to do those things. It's part of the purview of the presidency. The defamation action that she filed against him is known as Carol 1, but this is related to Carol 2. Okay, there are two of them. I think at the outset of the show, I inverted them, but this is Carol 2. She brought this one in 2022 against President Trump once they extended in New York. She helped to pass and change literally the laws that allowed her to sue. So in 2022, New York Adult Survivors Act, they say, we're going to extend the statute of limitations on this. You can now bring claims within this 1 year safe harbor window. And so bring your claims and then they'll close back up. So if you've ever had any prior claims, just come bring them. And her attorney and her were literally involved in petitioning to have that law changed. Kathy Hochul brought him out. They had a full press conference. Trump has consistently and unequivocally denied the allegations in both cases that there was any actual assault and that he defamed her. Now, Carol 2 proceeded to trial first because Carol 1 was delayed about immunity and whether the United States should be substituted in. Very complicated case history here. And so as a result of the significant evidentiary errors that we have raised here, Supreme Court, Carol came out and she got $5 million in Carol 2. Now, based on incorrect findings there, the district court then wrongly applied issue preclusion in Carol 1, meaning you don't need to relitigate what happened in Carol 2. So we've already settled that in Carol 2. So we're going to just bring that back over here. And then she got a second judgment. This prevented Trump from contesting the merits on the original case. She then got an unjust judgment of $83 million, okay, in Carol 1. On November 5th, in other words, lying about a woman, according to the jurors, is worse and more expensive of a mistake than actually grabbing them by the purse. On November 5th, the Second Circuit called for Carol to respond to two petitions. We appealed it, and of course, the courts of appeals denied it. On appeal, Trump challenged the admission of some evidence. Never should have come in. The Second Circuit, though, rejected Trump's arguments cursorily. Quickly. They just didn't care. The panel erroneously upheld admission of Leeds' testimony, and they said, well, it's a federal crime to commit assault on an airplane, so that's good enough for us. Like, what airplane? When? How long ago? Where were they coming? Where were they going? What's the proof? The panel also upheld her testimony after concluding that the sufficiency standard of admitting evidence is much lower than a conviction, so we can just let all this in. They also let in the Access Hollywood tape, and they also relied on legislative intent. They said, well, what did the legislators actually say versus what does the law say? Trump sought a rehearing. We had one dissenter who came out, and the judge was good. The Second Circuit denied this, but one judge was dissenting. As Judge Menashe explained, the panel embraced a series of anomalous holdings to affirm the lower level judgment. The panel opinion upheld the testimony of these two, Leeds and Stoyanov, by relying on statements in the congressional record to alter the effects of the rules. There is every reason to believe the testimony in this case would have failed standard Rule 403 analysis, the balancing test, saying it's way too harmful than it is helpful. It's not answering any of the actual allegations brought by Eugene. She said these things happened. Does that testimony help us determine whether this happened or not? No. It just says that Trump did something to them in an entirely separate incident, but they still brought it in anyways. It's like, oh, you robbed the bank. Oh, you robbed the bank. You robbed the bank. Okay, but you have no evidence that I robbed this bank. Too bad. You robbed the other one. So it kind of has all the hallmarks of guilty. And so you're guilty. It says in affirming the district court's admission of these two, the panel allowed conduct which does not meet the standard to qualify as an attempted assault. And by affirming the admission of the tape, they also erroneously sanctioned the admission of evidence of prior prior conduct to prove or corroborate this culpable conduct. And in the dissent, the judge said, these holdings conflict with our actual precedent. We can't interpret evidence that way because we've held previously we can't do that. And this produced a judgment that cannot be justified under the rules of evidence. The result was a jury verdict based on impermissible character evidence, right? You want to prove people guilty, not because a bunch of people come in and say they're bad people, but because you have evidence that ties them to the crime. Now, Carroll's trial also rested on fundamentally improper propensity evidence that courts ordinarily disavow. Can't come in, it's useless evidence. To greenlight the admission of such troubling evidence, the Second Circuit actually created and deepened significant circuit splits in order to make this charge stick. This court should grant a petition. We need to ensure uniformity across all of our circuits, and if misapplied, they're going to wreck it. Now, as you have explained, Supreme Court, before, the American legal tradition has long rejected reliance on propensity evidence, okay? It's evidence that is generalizing an earlier bad act into bad character, and then saying he did it now. Reliance on that undermines the principle a trial should be about the crime, not what sort of person the defendant is. We understand this concept. They enacted the federal rules of evidence. They say some allegations can come in by their own terms. It's not automatically admissible. We have to go through a deep assessment of the evidence. The circuits have taken various approaches on this, and there's a serious circuit split here. Some circuits, including our Second Circuit, have endorsed a truncated Rule 403 balancing test analysis, and they reject the rules, and they're instead relying on legislative history, which is history. It's not written in the rules. So in applying the Rule 403 evidence, the balancing test, to propensity evidence, the circuits have taken different approaches. We got 1st, 7th, 10th. They've correctly held it's the same analysis across any evidence coming in, but other circuits are saying no. The DC and the 5th Circuit have not even acknowledged this conflict, but by contrast, the 1st, 2nd, 3rd, 4th, 6th, and 8th seemingly have instructed the lower courts to apply Rule 403 less stringently and allow more evidence to come in that should be barred. Explaining, this wide circuit conflict has resulted in significant differences across the country in how evidence is handled. In evaluating this, the rule would focus heavily on the remoteness in time of the other act, okay? Like these are like 37 years ago, the one airplane lady. Remoteness in time reduces the reliability, and the propensity evidence against President Trump was old. It was based on allegations about incidents that supposedly occurred 44 years ago and 18 years ago. All of it before even E. Jean came up with her claims from 25 years ago. In addition, these incidents were separated by many years from Carroll's facially inconceivable encounter, which supposedly happened in 1996, a day which she couldn't recall forever until suddenly in the trial, oh yeah, I remember. Thus, as the dissenting judge in the Court of Appeal said, he observed, had the Second Circuit actually applied the proper standard, it would have excluded that testimony, or it would have issued a decision at the outer boundary of how this should come in before it hits the jury. But the Second Circuit erred in concluding that old testimony, old remoteness, it doesn't matter. They said, who cares? We need this evidence. The court then found that evidence was sufficiently similar in material respects, so it's probative, which is such a dumb standard. It's like, well, it sounds pretty good to me. It sounds similar. So we're going to let it in and the jury can decide. Finally, the Second Circuit dismisses remoteness. The Eighth Circuit has also dismissed remoteness. And in contrast, other circuits have said you can consider remoteness. It's very important. But they rejected this. And what they did is they relied on this one statement from one representative called Susan Molinari. They're going into the legislative history. What does the law say? Well, the law says we have to do something that we don't want to do. Okay, great. Let's ignore the law. What is the legislative history? What did the people who wrote the law say? Let's use that instead of the actual law, which is what they did. This court says you can't do that. All statutory interpretation begins with the text, okay? Don't look at the history. Look at the law. What they write. That's how you govern a country. The absence of any language that eliminates remoteness balancing cannot be squared with other modifications and other rules of evidence. Now, instead of grounding its analysis in the text, they didn't care. They went out and they went to find sponsors of the legislation and other nonsense from the remarks of the representatives. It's not the law. They even talked about Senator Bob Dole, and they went to law review articles and all this stuff, but it doesn't matter. The murky waters of congressional record don't help us interpret anything. And what you're doing here is trying to deepen a split by digging into that. The rule's very clear. Just interpret the rule appropriately, and we can put this to bed. Now, in cases alleging an assault, there is some admission components that a party committed an assault. There's an exception for that. Well, what about this? We can talk about this if it meets these standards. The act must constitute a crime to meet the two requirements. The act must constitute a crime, and the crime must involve at least one of the categories of conduct that's enumerated. Now, Trump was never investigated, let alone charged with any crime relating to any of these people at all. It's just their statement. Well, I was attacked. Okay, well, where's the evidence? Well, it's my testimony. Can we corroborate any of it? No. Okay, well, we need more than that. The district court erroneously concluded that Leeds falsely alleged, and Trump has denied, said, she said, all of it came out years after, 15 years, 20 years, 44 years, you saw the numbers. Rather than defending this erroneous holding, the Second Circuit created an alternative theory. Nobody even raised it, they just pulled it out of their butts, that Trump's alleged conduct would have somehow violated 18 U.S. Code 113, they would have called it simple assault. And that simple assault incorporated the common law definition of assault, which required no sexual element. And so unsurprisingly, then simple assault counts, and they could bring all the evidence in. Trump said, you guys can't make stuff up on the fly because you hate my guts. The Second Circuit said, yes, we can. We're the Second Circuit. And now we're at the Supreme Court. Under this approach, the statutory definition includes offenses with elements that entail deceitful conduct. And so their exception doesn't fit here. As Judge Menashe in the dissent explained, crimes that neither prototypically nor actually involve criminal assault still qualify as admissible evidence. This would not be a realistic assessment, though, of congressional intent. It requires the court to do more analysis, and the testimony that came in were neither crimes nor assaults, but they let the testimony come in anyways because they really wanted it in. But this is erroneous. Supreme Court, you got to step in and fix this. And we also have the Access Hollywood tape coming close to the end here, saying the federal rules of evidence also say we don't want propensity evidence in. Like, you robbed the bank before, so you definitely robbed the bank this time, even though we have no evidence of that. The rule says under 404B that evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion they acted in accordance with their character. Well, you are a bank robber because you've been convicted of that, so we think you're a bank robber now. No. At the same time, it also does permit someone to show, well, there could be some prior bad acts that can come in if you're trying to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of a mistake, or lack of an accident. So there are some propensity evidence that can come in if you're trying to prove one of these other things: intent, opportunity, motive, knowledge, identity, these different things. Very specific analysis that goes on in those cases. Now here, they said that the Access Hollywood tape was properly admitted under one of those exceptions. The Second Circuit, though, did not cite any of the non-propensity purposes. So in other words, you're using the propensity evidence to show that there was a plan, or they had intent or knowledge of the plan. You're not using the evidence to say that they actually committed the crime. It's to show some other aspect of the crime. They say they never pointed out what else they were trying to prove. Instead, they claimed the tape was modus operandi, which is not in the statute at all, which is interesting, and to corroborate testimony by allowing admission of this without requiring the evidence actually be tied to the rules, it conflicts with other circuits. And so they created a new modus operandi. It's not in the rules. You just read it. It's not in there. However, the courts have recognized a modus operandi can offer one way to accomplish one of the purposes. So for example, you could use that to establish identity, or one of the exceptions, but that's not what they did. And so the courts are interpreting the rules differently, and this case didn't involve any of those exceptions. We didn't need the evidence to show identity, or intent, or absence of mistake, or lack of accident. In fact, Trump has continuously and steadfastly denied that the incident ever occurred. And so any modus operandi evidence didn't serve any other purpose of non-propensity evidence. It was just to say Trump attacks women. The only reason that Carroll sought to admit this tape was to argue that if Trump had allegedly engaged in bad acts on other occasions, it's more likely that he did it here. Now, the purpose was solely to be prejudicial, and the rules say if it's more prejudicial than it is probative, you got to kick it out. And there was no exception under the 404B standards, and so they should not have done that. But now this Court of Appeals also directly conflicts with the DC Circuit right next door. The Second Circuit did not link the alleged corroboration to an otherwise improper purpose, instead wrongly held that the corroboration itself was a proper purpose. And so this is a mess, Supreme Court. We need you to come in and correct it. Therefore, President Trump respectfully requests that you grant this petition and weigh in on this case. The evidence should never have come in. This whole trial should never have happened because it was concocted by the Democrats, both trials. We covered it all here at length, and we are going to continue to do so until hopefully the Supreme Court comes back down and vacates these verdicts ultimately in the end.